Every time you swipe a credit card, sign a mortgage, or take out a student loan, you are participating in a financial system built on a hidden safety net. You take on debt with the implicit understanding that if absolute disaster strikes, there is a legal mechanism to wipe the slate clean and start over. But the permanent federal bankruptcy protection we rely on today did not exist until 1898. For the first century of the United States, failing to pay your debts did not mean a damaged credit score or a structured reorganization plan. It meant physical confinement, public humiliation, and a cycle of poverty from which escape was nearly impossible. What happened to people who couldn't pay before the government finally intervened? And how did a nation built on entrepreneurial risk operate when failure was treated as a moral crime? This is the story of how the right to fail was fought for and the brutal system that preceded it. In the early days of the American Republic, debt was not viewed as a mathematical calculation of risk, but as a profound moral failing. To owe money and be unable to repay it was considered a breach of the social contract, a sin punishable not just by financial ruin, but by the loss of physical liberty. The primary mechanism for dealing with insolvent individuals was the debtor's prison. This system, inherited directly from English common law, operated on a terrifyingly counterintuitive logic. If a creditor demanded payment and you could not produce the funds, local sheriffs were authorized to seize your property. If the sale of your goods fell short of the total owed, your body became the collateral. You were locked in a cell until the debt was satisfied. The absurdity of this system was immediately apparent to anyone who fell into its trap. Once incarcerated, a debtor could not ply their trade, manage a farm, or earn a wage. They were entirely dependent on the charity of friends, family, or sympathetic strangers, even to survive. Because in many jurisdictions, the prisoners were required to pay the jailer for their own food, heating, and bedding. If your family could not afford to sustain you, you starved. The jails were not filled with wealthy speculators, but with ordinary tradesmen, farmers affected by a bad harvest, and widows who had inherited their husbands' obligations. In cities like Boston and Philadelphia, it was not uncommon for a man to be imprisoned over a debt of just a few dollars, languishing for months while the fees owed to the jailer compounded, driving him deeper into an inescapable hole. Even the Founding Fathers were not immune to the ruthless mechanics of early American debt collection. Robert Morris, a man known as the financier of the Revolution, one of the few individuals to sign the Declaration of Independence, the Articles of Confederation, and the United States Constitution, found himself caught in the crushing gears of this system. After heavily speculating in land following the Revolutionary War, the market collapsed. Morris, whose personal credit had once kept George Washington's army supplied, could not meet his obligations. In 1798, he was arrested and thrown into the Prune Street debtor's prison in Philadelphia, where he remained locked away for more than 3 years. If a founding father could be reduced to begging for scraps from a jail cell, no citizen was safe from the absolute power of creditors. The Constitution actually granted the federal government the power to establish uniform laws on the subject of bankruptcies. But for decades, Congress refused to create a permanent system. The agrarian South fundamentally distrusted the financial mechanisms of the mercantile North. Southern planters viewed bankruptcy laws as a tool for Northern merchants to cheat honest farmers out of their rightful payments. When economic panic struck, the political pressure would occasionally force Congress to act, resulting in temporary, highly flawed legislation. The Bankruptcy Act of 1800 was the first attempt, passed in the wake of the Panic of 1797. But it was incredibly narrow, applying only to merchants, bankers, and brokers. An ordinary farmer or laborer could not voluntarily declare bankruptcy. Only their creditors could initiate the process to liquidate their assets. The law was wildly unpopular, viewed as a corrupt bailout for wealthy speculators, and Congress repealed it just 3 years later, plunging the nation back into an era where financial failure meant the total surrender of personal freedom. With the federal government abandoning its constitutional mandate to manage insolvency, the burden fell entirely on individual states. What emerged over the next 3 decades was a chaotic, predatory patchwork of local laws that made conducting interstate commerce a legal minefield. If a merchant in New York sold goods to a retailer in New Jersey, and that retailer defaulted, the rules of recovery depended entirely on which side of the Hudson River the legal battle was fought. States attempted to pass their own insolvency laws to provide some relief to their citizens, allowing them to surrender their assets in exchange for release from prison. But these state-level laws harbored a fatal constitutional flaw. Article 1, Section 10 of the United States Constitution explicitly forbade states from passing any law impairing the obligation of contracts. When the Supreme Court reviewed these state insolvency acts in cases like Sturgis versus Crown and Shield in 1819, they ruled that while states could release a debtor from physical imprisonment, they could not legally erase the underlying debt. This created a purgatory for the American debtor. You might be freed from a dank cell in Boston, but the ledger remained permanently stained. Any future wages you earned, any property you acquired, even tools of your trade, could be immediately seized by your old creditors. You were technically free to walk the streets, but economically, you remained a ghost, unable to legally own anything in your own name, completely excluded from the very capitalist engine the nation was trying to build. This legal paradox drove an entire class of Americans underground. Desperate men transferred property into the names of their wives or children, operating businesses through complex, shadowy proxies just to survive. The system incentivized fraud and deception because honesty simply guaranteed lifelong destitution. The political tide only began to turn in the 1820s, driven not by banking elites, but by the burgeoning labor movement and the rise of Jacksonian democracy. Working men's parties across the Northeast began to organize, pointing out the grotesque hypocrisy of a republic that celebrated liberty while throwing carpenters and shoemakers into dungeons over a $20 grocery tab. Petitions flooded state legislatures, detailing horrors of freezing cells and families torn apart. Newspapers published exposés on the sheer economic inefficiency of locking up able-bodied workers. Slowly, state by state, the practice of imprisonment for debt began to be abolished. New York ended it in 1831, followed by a cascade of other states. But removing the threat of the jail cell did not solve the fundamental problem of the debt itself. The financial obligations remained eternal. The breaking point arrived with the Panic of 1837, a massive speculative bubble in Western lands, fueled by unregulated state banknotes, spectacularly burst. Cotton prices collapsed. Banks suspended specie payments, meaning they refused to exchange paper money for gold or silver. Businesses shuttered by the thousands, and the streets of eastern cities filled with unemployed, destitute workers. The scale of the economic devastation was unprecedented. Hundreds of thousands of Americans were suddenly insolvent, crushed by debts they could never hope to repay in a depressed economy. This was no longer a localized issue of a few reckless speculators. It was a national crisis that threatened to permanently paralyze the American economy. Men who had been wealthy merchants one week were penniless the next, joining the ranks of ruined farmers and starving laborers. The sheer volume of outstanding, uncollectible debt created a political pressure cooker that forced Congress back into the bankruptcy arena. In 1841, the Whig Party, representing business and modernization interests, pushed through a radical new piece of legislation. The Bankruptcy Act of 1841 was revolutionary because it introduced a concept that fundamentally altered the relationship between citizen and capital: voluntary bankruptcy. For the very first time in American history, and indeed in the history of Anglo-American law, an individual did not have to wait for a creditor to drag them into court. A debtor, whether a merchant, a farmer, or a wage laborer, could proactively file for bankruptcy, surrender their assets, and receive a complete federal discharge of their debts. This legal innovation was nothing short of a paradigm shift. It transformed bankruptcy from a punitive weapon wielded by creditors into a mechanism for social and economic rehabilitation. It legally codified the idea that a citizen deserved a second chance, that economic failure was not a permanent moral stain, but a calculable risk inherent in a free market. Tens of thousands of Americans rushed to the courts to seek relief, eager to wash away the crushing burdens of the 1837 panic. But the victory was incredibly short-lived. The 1841 Act provoked immediate and ferocious backlash. Southern politicians decried it as an unconstitutional overreach that destroyed the sanctity of contracts. Creditors were furious, watching helplessly as millions of dollars in legally binding obligations were legally evaporated by federal judges. Rumors and heavily publicized scandals of debtors hiding assets before filing fueled a moral panic that the law was simply a license for theft. The political backlash was so intense that Congress repealed the act in 1843, just 13 months after it had gone into effect. The door to federal debt relief was slammed shut almost as soon as it had opened. The brief experiment with voluntary bankruptcy was over, and the United States was once again a nation without a safety net, leaving a battered populace to face the coming industrial revolution with no protection against the inherent volatility of modern capitalism. For the next quarter century, the United States operated without any federal bankruptcy framework. The economy expanded rapidly, driven by the explosive growth of railroads, the rise of industrial manufacturing, and the relentless push westward. But this growth was built on a fault line of immense financial instability. The absence of a unified system meant that when the inevitable panics struck, in 1857, and again during the massive economic dislocations of the Civil War, the wreckage was catastrophic. Without a legal mechanism to restructure debt or orderly liquidate assets, businesses simply collapsed overnight. Creditors engaged in a frantic first-come, first-served race to seize whatever property they could find, often destroying viable enterprises that might have survived with a temporary reprieve. The resulting chaos deepened economic depressions and prolonged the suffering of millions. The Civil War fundamentally reshaped the American economic landscape. The Union victory solidified the dominance of Northern industrial capitalism over Southern agrarianism, and the war effort itself necessitated a massive centralization of financial power. The federal government had created a national currency, the greenback, and established a system of nationally chartered banks. The old Jacksonian resistance to federal intervention in the economy was permanently broken. When the war ended, the nation was left with deep economic scars. Southern planters were financially ruined by the emancipation of enslaved people, who had previously been brutally counted as collateral for massive debts. Northern merchants who had extended credit to the South before the war were left holding worthless paper. In 1867, Congress responded to this post-war wreckage by passing the Third Federal Bankruptcy Act. This law was far more comprehensive than its predecessors. It retained the revolutionary concept of voluntary bankruptcy introduced in 1841, allowing individuals to seek relief. But it also established a vast administrative apparatus. It created a system of federal registers in bankruptcy to oversee proceedings and required debtors to pay substantial fees to access the system. The 1867 Act was intended to be permanent, a necessary piece of infrastructure for a modern, nationalizing economy. However, the execution of the law proved disastrous. The administrative fees were so high that genuinely impoverished debtors could not afford to declare bankruptcy. The system was quickly captured by a network of corrupt officials, predatory lawyers, and aggressive creditors who used the complex procedural rules to bleed estates dry before any funds could be distributed. In many cases, the administrative costs consumed the entirety of the debtor's assets. The law became a symbol of graft and inefficiency. Debtors found it too expensive to use, and creditors found it yielded virtually no returns. The public outcry became deafening. The law that was supposed to bring order to post-war finance had instead created a parasitic bureaucracy. Yielding to immense pressure from both business interests and agrarian reformers, Congress repealed the act in 1878. The repeal plunged the nation back into the chaotic state-level patchwork, just as the United States was entering the Gilded Age, an era of unprecedented corporate consolidation and brutal boom and bust cycles. Over the next 2 decades, the economy was hammered by the Panic of 1873 and the devastating Depression of 1893. During these crises, the lack of federal protection had horrific human consequences. When banks failed, they took the life savings of ordinary citizens with them. When railroads overextended and collapsed, tens of thousands of workers were thrown into the streets without warning. Foreclosures swept through the agricultural heartland, dispossessing families who had worked the land for generations. A new political force emerged in response to this suffering: the populist movement. Farmers in the West and South, crushed by deflation, high railroad shipping rates, and predatory lending practices, began to organize. They demanded radical economic reforms, including the free coinage of silver to inflate the money supply and ease their debt burdens. And they demanded, once again, a federal bankruptcy law. But this time, the political dynamics had shifted. It was no longer just desperate debtors pleading for relief. The massive corporations and national banks that now dominated the economy had also realized that the chaotic, state-by-state system of debt collection was incredibly inefficient. They needed a predictable, uniform set of rules to handle the inevitable failures that occurred in a continental, highly integrated market. The alignment of these seemingly opposing forces, desperate agrarian debtors seeking a safety net, and powerful corporate creditors seeking predictability, finally broke the legislative deadlock. For years, competing bills were debated in Congress. The Nelson Bill favored debtors, making it easy to discharge debts with minimal interference. The Tory Bill, drafted by a corporate lawyer named J. Torrey, favored creditors, emphasizing strict oversight and aggressive liquidation of assets. The final legislation would have to bridge this massive ideological divide, determining once and for all how the American legal system would balance the sanctity of a contract against the economic survival of a citizen. The legislative deadlock finally broke in the summer of 1898. After years of intense negotiation, Congress forged a compromise that merged the debtor-friendly provisions of the Nelson Bill with the creditor-friendly mechanics of the Tory Bill. On July 1, 1898, President William McKinley signed the Bankruptcy Act into law, fundamentally altering the architecture of American capitalism. This legislation was not a temporary emergency measure designed to expire when a crisis passed. It was a permanent, comprehensive federal system, the direct foundation of the bankruptcy code we operate under today. The 1898 Act was a masterpiece of political and economic compromise. For the creditors, it provided exactly what the powerful corporate trusts and national banks demanded: a uniform, predictable federal process. It outlawed the chaotic race to the courthouse, where creditors dismantled businesses piece by piece. Instead, it empowered federal bankruptcy referees to oversee an orderly liquidation, ensuring that all creditors of the same class were treated fairly and proportionally. But the true revolutionary power of the act lay in what it granted the debtor. It permanently enshrined the concept of voluntary bankruptcy into American law. A citizen could declare themselves insolvent, surrender their non-exempt assets to the court, and receive a total legal discharge from their debts. Crucially, the law recognized that stripping a person of absolutely everything they owned was both inhumane and economically counterproductive. It allowed debtors to keep certain exempt property, often their clothes, basic household goods, and the tools of their trade, ensuring they were not left completely destitute and reliant on public charity. This was the birth of the modern Fresh Start doctrine. The United States government had legally determined that the social value of returning a productive citizen to the economy outweighed the absolute sanctity of a financial contract. The immediate consequences were profound. Thousands of individuals and businesses crushed by the Depression of 1893 finally cleared their ledgers and began anew. But the broader, long-term effect was psychological. By removing the threat of lifelong financial ruin and physical imprisonment, the 1898 Act essentially subsidized risk. It allowed entrepreneurs to start businesses, borrow capital, and innovate, knowing that failure would not result in permanent exile from the economy. The rapid industrial expansion of the 20th century, the rise of the American middle class, and the explosion of consumer credit were all made possible because this hidden safety net was finally in place. Of course, the tension between the rights of the creditor and the relief of the debtor never truly disappeared. It simply moved into the courtroom. For over a century, the rules established in 1898 have been fiercely contested, amended, and rewritten. The Chandler Act of 1938 introduced the concept of corporate reorganization, allowing businesses to restructure their debts while keeping their doors open, the ancestor of modern Chapter 11. In 2005, aggressive lobbying by the credit card industry resulted in the Bankruptcy, Abuse Prevention, and Consumer Protection Act, making it significantly harder for ordinary consumers to wipe out their debts and permanently excluding most student loans from bankruptcy protection altogether. The fight over who deserves a fresh start and who must be held to their obligations remains one of the defining economic conflicts of our time. Does the ability to easily wipe away debt encourage reckless financial behavior? Or is it the essential safety net that allows true innovation and risk-taking in a capitalist society? The system you rely on today, the very concept that financial failure is a calculable risk rather than a permanent moral stain, was not inevitable. It was forced into existence by mass economic suffering, the political organizing of desperate citizens, and the realization that a modern economy simply cannot function if it throws its failures into a dark cell. The right to fail without losing your freedom is the hidden engine of American enterprise. To continue uncovering the hidden architecture of the systems that govern your daily life and the historical power struggles that built them, subscribe to the channel.